Welcome to ALP Corner, Family Law in the Heart of Houston.
Hello and welcome to ALP Corner, Family Law in the Heart of Houston with Allecia L. Pottinger, CEO of ALP Law Firm. I am your host, Kevin Rosenquist, and today's episode is From Conflict to Cooperation, the Mediation Advantage in Divorce. Allecia, great to see you.
Great to be here.
So something that we talked about, or that is talked about a lot in the law world is mediation. And it's a way to avoid going in front of a judge. It's a way to avoid a lot of contentious situations. So can you start just by kind of explaining what mediation is and how it works in the process of a divorce?
So what mediation is that you have a third party, the mediator, that's in the middle. And that mediator is trying to get an agreement with both sides where they come to the middle and they meet in the middle. So not one side won't get everything that they want, the other side won't get everything that they want, but you meet in the middle. And that works out. I find that it works out better, especially if you have kids, if the parents can come to an agreement in the divorce. Okay. And it is a mechanism that you don't have to go to court and have a judge who doesn't know you, a judge that is only making a decision on the slide based on the time that you have been in front of them in the court. You can make the decisions and make the determination of what you would like your divorce to look like in the future. And one of the things that there's this little law that says that a mediated settlement agreement cannot be overturned unless for very limited purposes. So if you and your spouse come up with some type of agreement and the judge doesn't like it, too bad. The judge has to sign off on that agreement. So y'all get to do whatever you can, make whatever agreements that you want, unless it's just something that is detrimental to the kids.
And it's important to note mediation and arbitration are two different things, because
Absolutely.
arbitration, they give you a ruling. It's not just like hey, let's all get along. It's more like this is what's going to happen, right?
It's a mini version of going to court.
Right.
Arbitration is, yes, definitely. And in Texas, not only do you have mediation, you have arbitration, which is the mini trial, but you also have what we call a collaborative law process that you can go through and collaborate and try to come up with a final decree of divorce. What happens is if it falls apart, you can't use the attorney that represented you in the collaboration. You have to get a new counsel. You can't use any of the information that was disclosed in the collaborative process, and you kind of like start from fresh. But there are more than one means to what we call alternative resolutions in Texas.
And so if the mediation process, they try it, doesn't work, does it go to arbitration then? Or does it go to trial?
It goes to trial.
Okay.
The only time that you can go to arbitration is if the parties agree to arbitrate. And the times that a party may agree to arbitrate is, let's say the court, they're ready to get divorced, and the court, the earliest that they have is, as far as the trial date, is in August, and this is in March. They might say, I'd rather just go to an arbitrator. They can get me in a couple of weeks and we could get this over with. Mm-hmm. And then in that scenario, that would be a good time to go to an arbitrator, but you have to agree in order to go through arbitration. The trial don't have to agree, but bottom line, issues that would have been taken care of in mediation, all those are taken to the court. But you find sometimes it's a scenario where the parties can piecemeal an agreement together and have the judge do the other part. For example, the parties may be able to agree on what they're going to do as far as the parenting plan with the children. but they have a huge chasm with what they're going to do with the property. And so they may take the property issues to court and just have an agreement on the child issue or vice versa. So
Okay.
it doesn't always that you have to take everything to the court. You can work out some arrangement for through mediation, through that alternative dispute resolution.
Maybe you said this already and I missed it, but do you have to try mediation first? Do they require that?
Let me put it this way. Some courts require that you mediate for temporary orders, not on final, but temporary orders. And then they require that you mediate on final orders. So it's twice that they may require you to mediate, but definitely you will mediate at least one time through going through a divorce.
Ballpark figure or exact if you've got it. How many times does mediation, do things get solved in mediation?
I would say at least 70% of the time it gets, yes, it
That's pretty
gets,
good.
yeah. It works out unless you have really a hard-headed individual, I hate to say it,
Mhm.
or someone that's dug in their heels or if the other side is just being absolutely unreasonable
Yeah.
and then you go to trial. But trial gets expensive. And so, parties can save a lot of money just by going through that mediation process. So
Absolutely.
it's a win-win situation for the parties.
Can you kind of walk us through the process, what it looks like?
Hmm. Yes. So the parties will either the court will order a mediator, or I should say, send you to a mediator, or you can agree on the mediator. Once you agree on the mediator, you have to, everybody is like herding cats trying to get two attorneys and two parties together for a particular date and the mediator. But once you set that date, what ends up happening, you set that date, is either going to be for 4 hours or it's going to be for 8 hours. Typically, it's going to be the 4 hours unless you're dealing with property and children, and then you're looking at about the 8 hour. And
Okay.
so what ends up happening is that mediator is in that middle, and they will start with what we call the petitioners first, the person who filed for divorce. They'll start with them first because they're the petitioner, they have the burden of proof. Once they start with them, they'll the next thing that they do, they get, what the wish list. They say, I want this, I want that, I want that. And then the mediator comes and takes it to the other side. And the other side is the responded side. And they'll say, this is what the other party has said that they would like to do. And of course, you'll get the, I'm not going to do that, and whatever. And the mediator will say, well, I get it. I'm just giving you, what they're proposing. What would you like as a counter offer? Can we meet somewhere in the middle? And they'll go back over to the other side, and then they'll, work with them some, and it goes back and forth until finally you can come up with an agreement. And that process, it seems like a hurry up and wait, because you're
Mhm.
talking and you're trying to get there, and then you have to wait for the other side. But bottom line, it is very effective and it works out because you come out of mediation knowing what you're going to have in the future versus walking out of court and not knowing how the judge is going to rule. So it benefits the parties
So
to
they're always separate. The two parties never in the same room together during mediation?
No, that happens a lot of times in civil court, although
Okay.
family is civil, but the parties may come together and they call that the caucus. But the parties in family law, no, it never works out. I've tried to do that to get the parties together, as a mediator, and it just,
Mhm.
Kevin, it just was not. It was not good. And so most mediators, especially experienced mediators, are not going to have the parties together unless it's something that they really need to work out. Like Johnny has baseball games and mom knows about the schedule and dad is trying to figure out how we're going to do Cub Scouts and stuff like that. You might put them in the room together, but that's primarily after most of everything has been resolved and you're just working out some little kinks. But for the most part, the parties stay separate.
So
Yeah.
you never get that Hollywood style, oh, let's just stay together in the mediation room, huh?
Oh no, no, that's only Hollywood. As a matter of fact, you might get that clawing and hissing and stuff. It does not go well with parties being in the same room.
So who is this mediator?
Typically, a mediator is going to be an attorney, but the statutory they don't necessarily have to be an attorney, but they need to have training in mediation and also in family law mediation.
Okay.
And so credentials are important, and you look for someone who does have experience, not only as a mediator, but also has some history as far as family law. Have they tried a case? Have they been in front of the judges? Because then their knowledge and training that you're looking and relying on to get that to the other party. So for example, you'll have a mediator to say, I've been in so and so's court on numerous occasions. You're not going to get what you're thinking you're going to get in that court. So it's
Mhm.
best that you agree with this versus trying to go to court to get something that you won't be able to get in that court. Or they could say, this judge leans kind of more so toward this versus that. And so if you're going to ask for something, you probably should go for the this rather than the that. And most of it is dealing with 50-50 split and as far as access and possession, one party being 1 week on, 1 week off, that type of thing. So,
Okay.
you have to know your judges.
Yeah, you got to have a certain temperament, I suppose, to be a mediator, huh?
Absolutely. It takes patience.
Yeah.
It takes patience, most definitely.
How do they negotiate, or how do they facilitate the negotiation and the communication, and like what have you seen a good mediator be able to accomplish?
What you need to know about mediation is a strictly confidential process. So if you leave the mediation and you feel like something was said in mediation that you want to bring up in court, you can't do that. You
Okay.
can't even subpoena the mediator to come into court to testify about what happened in mediation. And so when you find a mediator that's experienced, they know what particular hot buttons may push another person. And so they're in this room, somebody said a hot button issue. So they'll leave that hot button issue off the table and not bring it to the other room, but at the same token, still try to weave a web that will work to get parties to come together without using that hot button. And so that is where an experienced mediator comes into play.
Yeah, that's yeah, there's an art to that to trying to do that, I would imagine. That's something that,
Absolutely.
yeah, yeah.
Absolutely.
I mean, I think it makes sense that you can't use the mediation stuff in a court, because that would sort of like maybe limit what people are willing to say or negotiate or whatever, if you know it could be used against you later.
Exactly. So good mediators I would say they intuitively know what not to take back to the other room and not
Mhm.
in order to get the parties to settle. One of the things when you said the parties don't come together, when I talk about the parties don't come together, sometime a mediator may pull the attorneys in together and say, look, your client is being unreasonable, and or your client is being unreasonable. Let's see what we can do. What are the hot buttons here? Can you go back and talk to your client about doing X, Y, and Z? So sometimes the caucus between the attorneys is pretty good too.
Can be, it can be
Yeah.
productive. Yeah.
Yes.
How do you coach your clients that, before mediation? How do you prep them? What do you say? Hey, this is what this is going to look like. This is what I need from you. What's your go-to there advice?
At that particular time, if I'm dealing with clients, I'll have we try to go over what we call in a divorce a spreadsheet of what the assets are in the estate, and we put them on that spreadsheet, and we do a division of you get this, you get this, and at the bottom we have our spreadsheets will do a tally on what the percentage of the estate that each person is getting. So we try to get to a 50-50 state, a 50-50 split. And what I do is I talk to my clients about, okay, can you give up this? Can you give up that? What is it that you're really wanting? If you could have your druthers, I understand that you may want this, but the law may only require you to get this. What would you like me to take into, and what would you like to start off with as an offer? And I hear them out because, a lot of times they may have things that are some good plans that they have thought about and felt like would work with their situation and their property, etc. And so it's the time for me to tell them what happens in mediation, what it looks like, talk to them about the fact that it is a confidential process, and just let them know that it's very informal, because sometimes they're thinking, oh my God, it's like court and I need to dress up and this and that. And I'm saying, no, this is very informal. You don't have to worry if there's something that you don't want to go to the other side. Just make that you could speak your piece with the mediator, but just make it sure that you let the mediator know what you don't want to have taken over to the other room.
Very good point. That's something that's very important to remember. You can be honest, and you can
right,
open up a little bit, but just let them know if you shouldn't say something to the other side.
Correct.
Great point. All right. Well, thank you for tuning into ALP Corner, Family Law in the Heart of Houston with Allecia L. Pottinger. To connect with Allecia and her team, head to alplawfirm.com, and don't forget to like and subscribe to our channel. Allecia, it's always great to see you. Thanks so much for the conversation. Really appreciate it.
Thank you, Kevin. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.